Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about stock options in employment law. Cases that should have gone to the Supreme Court of Canada, but didn't. Francis Battiston was working for the Microsoft company when he received an email indicating that, given his tenure of service, he was able to be eligible for stock options. He needed to respond to the email indicating that he'd read and understood the terms of the stock option offer and accepted those terms. He did not read and understand the terms and accepted the offer nevertheless. Because he didn't read and understand the terms, he didn't realize that when he was later terminated by the company and given a notice period, he had not worked a sufficient amount of time for the stock options that he had accepted to vest. The agreement related to the stock options prevented the stock options from vesting for a certain period of time and did not include any notice period if he was terminated. This meant that Mr. Battiston never got the stock options that he had accepted. Ultimately, when he was terminated, he sued, arguing that he was entitled to those stock options and the benefits of the stocks based on his tenure of service with the company. He originally won his trial, but the appeal was allowed, and he sought leave to appeal to the Supreme Court of Canada, which denied leave. And this case does raise an important issue. A notice period. The purpose of a notice period in employment law is to provide somebody a period of time during which they have the same period of employment and type of employment that they otherwise would have, but allows them the opportunity to look for other employment. It's designed to prevent people from suffering damage as a result of an employer's decision to terminate a person without cause. And yet, despite the fact that Mr. Battiston was entitled to this notice period and was entitled to have compensation in the notice period as though he were working for the company was effectively able to, by the imposition unilaterally of these terms of acceptance of the stock options, prevent him from having what he would otherwise legally be entitled to. He characterized this as an oppressive type of provision in the contract, arguing that this effectively violated his employment law rights. And this is significant because it could essentially be used by any company to change the terms of employment before it designed to terminate somebody in order to put them in a less advantageous position vis-a-vis the employer at the point that they are terminated. It could effectively be used by companies to force people into agreements that negatively and adversely affect their employment law-related rights while still protecting the rights of the company. And this, of course, exploits the power imbalance between employees and employers. The Supreme Court of Canada, I think, missed the opportunity to see beyond the four corners of this case and into the way that contracts of adhesion like this can be used to essentially eliminate employment law rights for many individuals, particularly those working for large corporations who can draft very incoherent and difficult to decipher language about benefits and packages that are being offered to employees. Hopefully the Supreme Court of Canada gets another case in which he can see that this is an opportunity for abuse by employers and for exploitation, and takes the opportunity to denounce this type of conduct. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.